Hello, and welcome to this podcast presented by LexisNexis. Because the law is everywhere, at the heart of our lives and our discussions, this series brought to you by LexisNexis and guests will cover current issues that impact us daily. I am joined today by Kain and Adam Goldenberg from McCarthy Tétrault, LLP. Kain is a partner at McCarthy Tétrault, where he is the head and co-founder of its National Appellate Litigation Group. He has a broad litigation practice which focuses on both private and public law. Mr. Kain has acted in over 20 appeals at the Supreme Court of Canada, along with numerous cases in the federal and provincial appellate courts. He has authored and co-authored a wide variety of articles in legal publications, including the new book on good faith in Canadian contract law, publishing November 2024 by LexisNexis Canada. Adam Goldenberg is a partner in McCarthy Tétrault's litigation department, where he maintains a diverse commercial and public law disputes practice. He has been counsel in 24 appeals to the Supreme Court of Canada and in the courts of British Columbia, Alberta, Saskatchewan, Manitoba, Ontario, New Brunswick, and the federal courts. Thank you, Brandon and Adam, for joining us today.
Thank you, Monica. It's a pleasure to be with you. And Brandon, congratulations. Good Faith in Canadian Contract Law is the book, and what a monumental achievement it is.
Thank you very much, Adam. It's great to be here.
So, Brandon, most of us don't wake up in the morning and think, you know what I'm going to do in the side of my very busy commercial and appellate litigation practice? I'm going to write a 2-volume, 3,000-page authoritative text on an important and urgently interesting issue in contract law. What on earth possessed you, my friend, to put this book together?
Thank you for that question, Adam. I was always interested in this topic. A very long time ago, I started at McCarthy's as a first-year associate, actually in the Calgary office of McCarthy's. And I became involved in some files where, various issues of good faith in contracting arose and, began to develop a bit of an awareness of the law. And, it wasn't something that I had actually been taught in contracts class in law school, at least overtly anyway. And I was sort of intrigued by its underlying themes. There were issues of morality and certainty in the law. I had come from a background in philosophy prior to law school. And so it really opened a window into an aspect of contract that was very different from the black letter, body of rules I had sort of associated with it until then.
Sure.
And it also deals with something that's really at the margins of the law. I've always sort of been fascinated with legal doctrines that are not well defined and give courts, a bit of a residual flexibility. And good faith is really right in that zone. So, beginning from that position, I just thought it was a really interesting area and, there's a lot of potential for courts to develop it. Certainly back in 2004, when I started as a lawyer, the law was all over the map. And over the years, my interest in it, grew, and I was fortunate to be involved in the Basine and Hernu appeal at the Supreme Court, which is when things really sort of took off.
So, all right, Basine is your gateway case when it comes to shaping the law of good faith as counsel, because of course you're not just one who writes about it from the sidelines. You've been right there on the front line in the Supreme Court of Canada as the doctrine has developed and been clarified in common law contract law. Tell us about the Basine case. How did it come about? How did you become involved in it? I know that you and our late mentor, colleague, and friend Neil Finkelstein won that case in the Supreme Court, but where did it come from and how did it catalyze what has now become this magisterial tome that you've authored?
Well, this is actually, an interesting story, and it's one I talk about a little bit in the acknowledgments section of the book. So back in 2013, I was just, working away in my office on something and received a telephone call from the son of Harish Basine, who was the appellant in the Basine case. And he had won his case at trial, but had recently lost it in the Alberta Court of Appeal. And his son was looking for a lawyer to try to take it up to the Supreme Court. And so, at the time, I didn't have a lot of experience at the Supreme Court. And the reason he contacted me was actually because I'd just written a blog post about the the Court of Appeals judgment. So, for all of those who are wondering whether they should do legal blogging, I would wholeheartedly endorse it. It's one of those things in life where, it's totally serendipitous, because if I hadn't written that post, I never would have gotten involved in the case, and who knows where my life would have gone. So the Bassines, they were interviewing lawyers from a couple of different firms for the position. And so, we were, competing perhaps with other firms for the mandate. And so I immediately reached out to my friend and mentor, Neil Finkelstein, who you mentioned, to see if he could join for pitch. And Neil, for those who don't know him, he was a legendary litigator at McCarthy's, and had done a ton of cases at the Supreme Court of Canada. Like, I think he was well over 20 by that time. And, he had a lot of wisdom and experience. And so it's funny, when I brought up the Court of Appeal decision for him to look at, he actually told me to bring him the trial judge's decision instead. So, he kind of knew that the key to getting leave at the Supreme Court in this case was not the fact that it raised the legal issue of good faith in contracts, because frankly, everyone knew that good faith was a big issue, and that at some point the Supreme Court of Canada was going to have to weigh in on it. The key to getting leave was really the fact that what we had was a trial decision in which the judge had made extensive findings of dishonesty and bad faith. Right. And that's actually something that's quite rare. You don't usually see trial judges do that. Sure. And so, from a Supreme Court perspective, what it would do would give them a strong sort of factual platform from which to kind of develop the law. And, Neil and his wisdom kind of saw that point. And so we developed our leave argument around that. And then we were retained with a team that included, Professor John McCamus, great academic authority on contracts and restitution. And he had written many of the seminal articles on good faith. And also Stephen Morrow, who is an excellent Toronto labor and employment lawyer who had clerked at the Supreme Court. And the four of us really, worked on this leave to appeal factum. And, ultimately, to our excitement, we were granted leave in the summer of 2013. And the leave panel was Chief Justice McLaughlin, Justice Abella, and Justice Cromwell, for anyone who's wondering. Kind of a very strong panel.
Good to say, some real heavy hitters that decided they wanted to hear your case.
Definitely. And so we were definitely happy about that. And so we argued the case, later that year, and the hearing was quite interesting. So the lead counsel for the other side was Eli Letterman at Lenzner's, and he did an excellent job. But it was apparent from some of the questions the panel was asking that they were very concerned about the findings of dishonesty the trial judge had made. And we're really not buying the Court of Appeals conclusion that, because this was a commercial agreement and had an entire agreement clause, there was just no room for a duty of good faith. They were quite skeptical about that. And I will note too that, of the 7 judges who heard the case, 2 of them, Justices Labelle and Wagner, were civilian jurists from Quebec.
Sure.
And, and as you know, this is a point that increased in prominence in Cal and Waste Tech, but they were asking some fairly pointed questions about why the common law was unable to accommodate a duty of good faith, when the civil law had long done so. So, that was a theme, going back to the very, the hearing in Bassine. So, and then we also got some difficult questions around the damages piece of the case. And so I would just say, leaving this point, an important part of the appeal I would highlight is that Neil made the strategic decision really heading into the appeal to pitch the case in a narrow and targeted way. And so, rather than argue that there should be a general duty of good faith throughout the law of contract, which is kind of how we had framed it in the factum, he sort of focused on convincing the court that, at a minimum, there should be a duty of honesty when parties are performing a contract.
Right.
And so, and the court accepted that position and introduced the duty of honest performance along with the general organizing principle, not duty, organizing principle of good faith in Bassine. And this was, to me, Adam, was a great lesson about advocacy at the Supreme Court of Canada, is really focus on winning your case, not on reforming the law. Because if you can win your case, then the legal reform may follow. But if you focus on legal reform instead of winning your case, then you may end up pitching your argument too broadly and lose on the merits. So.
Sure. But let me put that back to you, Brandon, because you pointed out that Neil's starting point was the findings of fact that the trial judge had made, which were exceptional in this case. And we're going to hear about this again when we come to the Callow case, because there were similar findings of fact that were very helpful when we got that case to the Supreme Court. What's the answer to the criticism that, sure, your job in the Supreme Court as an advocate is to win your case and not to fix the law in all of its deficiencies, but at the same time, we don't want hard facts creating bad law or problematic precedents and developing law in the direction that it's going to be difficult for lower courts to follow, which is one of the criticisms that has flowed from the Bassine case and that's gone nowhere in terms of abating since the Callow decision followed it. What's the answer to that objection?
Well, no, I mean, it's a great question. And I mean, certainly, we were privileged in Bassine and Callow to be on the side of the party in whose favor, those findings of dishonesty had been made by the trial judge. So, it was fairly easy for us to, focus on those facts and argue that the law and the legal development should really follow that. I think on the other side of the ledger, there are certain, concerns in the law, that I talk about in the book, I would frame as also being organizing principles in the law of contract, which would be things like freedom of contract, commercial certainty. These are concerns that really go back in the common law hundreds of years. And there are many cases where those principles have come into opposition with the principle of good faith, and have actually been given greater weight by the courts. And one of the things I talk about in my book is that, the way that these principles operate is very much driven by the context. I mean, they don't have an absolute or immutable weight in any particular situation. It's
Sure.
very much, it's driven by contextual factors like, are these commercially sophisticated parties? Is it an adhesionary agreement? Is it a relational contract? That kind of thing. And so I think as an advocate, if you're dealing with bad facts in terms of negative findings of conduct against your client, you want to try to identify some principles on the other side, that you can, try to develop as a reason for the court to not perhaps develop the law as broadly as the other side may need it.
Well, and I have no doubt that counsel who find themselves in that position will find helpful guidance in your book. Talking of which, let's go back to Bassine and the
Sure.
writing of the book. The decision in Bassine comes out. You've won. It's a landmark decision in Canadian contract law. Take us from that moment, the jubilation of having prevailed for the Bassines in the Supreme Court of Canada, to the decision to write the book and how you approached the problem that you tackled in writing the book.
Yeah, well, no, so I'm glad you asked that question. So just as a preliminary matter, I had been toying with the idea of writing a book on good faith even before Bassine. But, when the decision came out, I realized that this was obviously going to be, it was going to become a very big area in Canadian law over the next few decades. Right. And so I started to get serious about it. And there were several people at McCarthy's who encouraged me to write the book after Bassine, including Neil. So just in terms of an impetus to write the book, it was obviously an important one. But it also affected the content of the book itself, because actually Bassine created a bit of a challenge for me. So prior to the decision, when I thought about writing a book on good faith and contracts, I thought I could do it in like 200 to 300 pages, and maybe focus on a handful of areas in which specific duties of good faith had emerged. I wasn't thinking about good faith at the time as a general organizing principle. And so Bassine changed that, because the way that Justice Cromwell framed good faith was really as an overarching feature of contract law that explained or had a key role in a whole bunch of dimensions of it.
Right.
And so, as you know, Adam, under good faith, Bassine is not a duty. It's really a broader concept that judges can draw on when they're developing the law, particularly in hard cases. And it's manifested in a number of, discrete doctrines, and there's lots that I talk about in my book, like unconscionability or presumptions of reasonableness and contractual interpretation and so forth. It's not just things like the duty of honest performance. And so when I teach good faith, or I have in the past in an advanced contracts class at Western, and when I do, I try to explain it as though it were an analog to freedom of contract. Like, you would never bring a claim in a court seeking damages for breach of freedom of contract. And it's the same thing with good faith. Like, you shouldn't try to bring a claim seeking damages for breach of the organizing principle of good faith. It's not a positive duty in that sense. It's really, like freedom of contract, a philosophical principle that lies at the heart of contract law. And both can give rise to specific doctrines whose breach may themselves sound in damages or produce some other remedy. But they play a more fundamental role. And so because of all that, I was sort of forced to reevaluate my plan for a book. And I ultimately realized that I could not write a book about good faith and contract law without writing a book about contract law in general, just because the influence that good faith has on contract law is so pervasive. There's so much history behind it. It's not really possible to deal with good faith as an isolated phenomenon. And so you'll see when my book comes out, it's very much a journey through the law of contracts in Canada, which focuses on how good faith affects multiple parts of it. And to do that properly, I needed to provide background context about different parts of contract laws writing. So you'll find discussions of things like, for example, when is a contract enforceable based on things like, essential terms or certainty, or how does the law of contractual interpretation work? I needed to kind of explain those in the book as well in order to contextualize those areas of the law before I could really move on to explain how good faith operates within them. So there's quite a bit of discussion about contract law generally.
Fair enough. Okay, so you've already started to sort of walk us through how the book is organized. What's the organizing principle about this book, about the organizing principle of good faith?
The organizing principle about the book is that I tried to make it as clear and understandable as I could, while trying to be comprehensive at the same time. Because again, there's just so much here that I find fascinating. And so, like at a high level, what I have done is I've divided the book into 8 chapters, and I can walk you through those if that would be of interest. So the first chapter is really an introductory one, and it provides a bit of a preliminary outline of what am I talking about when I'm talking about good faith and contracts? What's the book going to address? And it introduces the idea of there being competing organizing principles in the law of contracts, freedom of contract, and commercial certainty, and examines how those principles, as opposed to just good faith, have been treated by Canadian courts. And actually, one of my favorite parts of this chapter that I really enjoyed writing was a bit of a historical overview of good faith. So, going back to Roman law and then looking at its acceptance, in early English case law in the 17th and 18th centuries, and then how English law really hardened in the 19th century, based on various, factors. And then there being a modern resurgence of good faith in Canadian law in the 20th century, which coincided with the Supreme Court of Canada's independence from the Privy Council and the enactment of the Charter and other broader sort of trends, ultimately culminating in Basine. And it also talks about how good faith in common law Canada is dealt with comparatively in other jurisdictions. So there's this is a big issue internationally, as I'm sure you know, and so Quebec, England, the United States, Australia, Europe, some of those other jurisdictions are ones that I talk about in this chapter, and provide an overview of how they deal with it.
Well,
go ahead.
I was just going to say, I can scarcely get off a plane in another common law jurisdiction before lawyers are talking to me about the problem of good faith. So I'm glad that I will now be better equipped to explain the Canadian perspective when I have those conversations.
Well, it will. Yeah, I hope so. I mean, certainly you'll have a lot of material to draw from, Adam, and formulating a response. And actually, so the second chapter that is in the book is actually designed to provide readers with an overview of what is the organizing principle of good faith itself in Basine? How is it dealt with in Canada? And so it's very much, it discusses how it's different than a freestanding duty or implied term. And I draw, here on the work of the legal philosopher Ronald Dworkin, which Justice Cromwell cited in Basine. And you may remember we cited in our Factum and Callow.
You're giving me flashbacks to undergrad political philosophy class, Brandon, but I'll forgive you that.
And so, he's got a very interesting and obviously groundbreaking distinction between, principles and rules. And I try to situate, what the court is doing in Basine with the organizing principle within that distinction. And it discusses, how there are essential elements of the organizing principle in Basine. So, there's really 2. There has to be a party that possesses a legitimate contractual interest, and then the counterparty has to fail to pay appropriate regard to it. And so part of this talks about how, there are concepts like reasonable expectations relate to legitimate contractual interests. And offers some definitions of some of the primary standards of inappropriate behavior that would contravene the principle, which are really dishonesty, unreasonableness, and bad faith. And there's also, discussion here about how, as a point I was talking about earlier, about how context affects the organizing principle. What are some of the factors that, courts will draw on in terms of giving good faith versus other principles like freedom of contract more or less weight in particular scenarios. Those first two chapters, Adam, are really the most, theoretical. After that, it becomes a lot more practical, I think, and begins to really focus on specific doctrines, that deal with the organizing principle. And so the scheme of the book from this point is really based on, the life of a contract. So chapter 3 starts with, what happens, how does good faith operate where parties engage in contractual negotiations and they ultimately fail? And as is it possible for, one party to sue the other and say you acted, dishonestly and therefore deprive me of the ability to enter into a contract with you? There's a whole bunch of controversy about whether there's a duty of good faith in that setting. And so this part of the book, examines the pockets of law that have arisen in which courts have been willing to sort of recognize duties of good faith, and also talks about some other sort of related doctrines that could be relevant in contractual negotiations like estoppel and good faith bargaining and labor law. And then chapter 4 is kind of the flip side of this. It's like, how does good faith operate where parties negotiate successfully, where they actually reach a contract? So there is contractual formation, but one of the parties later wants to set it aside or rectify it or seek some sort of a remedy based on, the counterparty's misconduct during the formation process. And this is actually one of the largest chapters in the book because there's just so many doctrines in the law that deal with this, like duress, unilateral mistake, fraudulent misrepresentation, duties of disclosure and insurance contracts, you name it. This is why the book's 3,000 pages. So they're all examined. They're all examined at length here. And then after that, chapters 5 and 6 look at the duties of good faith as they arise at the stage of contractual performance. And this is probably like when most lawyers in Canada think about good faith. This is probably what they associate with Basine and with good faith. It's things like chapter 5 focuses on what I call the relational duties of good faith. And those are ones that are implied by law in specific types of relationships like employment, insurance, franchises, where there's a power imbalance between the parties. That's chapter 5. Chapter 6 is what I focuses on what I call the situational duties of good faith. And they're the ones that they can arise in contracts of any type, but only in certain types of situations. And they include the 4 that, the court and Basine recognize. So the duty of honest performance, discretion, cooperation, and not evading obligations. And then I have two remaining chapters, 7 and 8, that focus a bit more on how good faith operates in practice. And so the first chapter 7 deals with contractual interpretation, explores how good faith is relevant as a principle of interpretation, but also how, parties sometimes look to contract out through exemption clauses of good faith. So is that permissible? How does Turcon sort of relate to that? And then in chapter 8, that's my remedies chapter, which is also one of the longest, and really looks at, what are the remedies for all the doctrines of good faith I talked about in chapters 3 to 6 in negotiations, formation, and performance. And there's also a bit of a discussion of how good faith may be an organizing principle in the law of remedies itself. So that's kind of the overview of it. I probably went on longer than I should have, but
no, but
hopefully that's helpful.
You have given us an accurate picture, Brandon, of just how thorough of a treatment this really is. And it sounds like this would have been a real colossal undertaking on your part. I mean, we mentioned earlier, there's 2 volumes, 3,000 pages. You really do trace the history of this concept back to, even before we have the modern development of the common law. How did you go about writing this, and what was most difficult for you in putting these concepts, gathering this information, then committing them to the page?
Well, I mean, obviously the biggest challenge was just writing it while still maintaining a family and a law practice. So that's,
yeah, fair.
There's that. Obviously, it was very difficult to do. But I mean, in terms of actually writing it, I think one of the biggest problems was that, I had to write in the book in certain areas about fairly specialized areas of legal practice that I wasn't very familiar with. So, my practice focuses on litigation work and opinions work, and I'm something of a generalist, but It took quite a bit of reading to understand how certain areas of the law, like employment law, for example, or insurance law, really operate. And so obviously there's a lot of excellent books in those areas, and my book is not intended as a substitute for them. But I tried to provide context, sufficient context in those areas to set up the discussion for how good faith operates. And so that was a bit of a challenge in doing that. And then the other thing was, I had to really teach myself about how good faith operates in legal systems outside common law Canada, like Quebec. And so, I'm not a civilian trained lawyer. I'm not fluent in French. So that was hard, but I was fortunate, there are some excellent high quality English language books on Quebec contract law that are out now. And so I relied on those, and I was able also to get some rough translations of some leading French texts. And so that was really helpful. And then the other thing, I guess, was that, there's just a lot of change because this took me a decade to do. So as you can imagine, the law underwent a lot of revision over that time. And so there were literally hundreds of decisions over the decade that I constantly had to be updating, parts of the book and integrating into it. And so that led to a lot of reflection at times.
Okay, so you're trying to keep up with the tide of decisions that are applying Basine and developing the law as you are maintaining your busy law practice and keeping track of your busy children and your family life, and you're doing all of that successfully. And then along come Callow and Waste Tech, which you've mentioned already, and which, as everyone listening who follows this area of the law will know, were important post-Basine developments in the law of good faith in common law contract law. And you were once again a leading player in the saga that led to that jurisprudential development. You were lead counsel for the appellant in Callow. I was your junior. We had a fabulous time. We won the case for Chris Callow and his company and felt great about that. But how did that development, the Callow decision and the Waste Tech decision that was decided at the same time, affect the book and the ultimate perspective that you offer your readers on the organizing principle?
Yeah, no, that's a great question. And, they were definitely the two most significant decisions, obviously, to come down during the drafting process. And so I had to revise large parts of my manuscript to respond to them, but differently, different in each of their own ways. And so obviously, as you know, Adam, having, done the Callow case together, there were a lot of questions about, the duty of honest performance and I guess good faith generally after Basine. And so, some authors had thought that, in the first few years after Basine was released, there was actually a bit of a revolt by lower courts, with some judges giving it a very narrow sort of reading. And the Callow appeal or decision by the Ontario Court of Appeal was really in that vein. It was a narrow reading of Basine. And we really obtained leave to appeal to it, to the Supreme Court by arguing that, the court needed to provide a course correction and really confirm that Basine meant what it said. And so, when the court, in Callow at the Supreme Court decided the case, it actually made some modifications to the duty of honest performance that I had to rewrite certain parts of my dishonest performance section to deal with. So this distinction that it drew between a duty of disclosure on the one hand, which the duty does not require, and a duty to correct, which can arise in some settings, I think it was already latent in Basine, and that was certainly our argument in Callow. But it really dealt with that at a much deeper level, and so I had to sort of revise that aspect of the book to kind of deal with that. And there were other aspects of Callow that I must say were somewhat more surprising, and I think these were found, I think, in the disagreements between the minority and the majority reasons. And so one issue that we saw open up a fundamental rift about really was whether the duty of honest performance protects the expectation interest or only the reliance interest, and consequently how damages for that should sort of be measured. And this is something it's funny, like it actually tracks on some level a larger debate between certain contract law theorists like Charles Freed, who view the function of contract as being the protection of promises, and other contract law theorists like Grant Gilmore, who view, contract as really something that protects the reliance interest. The majority and minority reasons in Callow are kind of a microcosm of that academic debate, without expressly acknowledging it. And so, that I found, was quite important, and I had to deal with that in the book. And you'll see that my view is, I think the majority of reasons of justice Gazier do have the better part of the argument, and that the duty does protect the expectation interest. But that was something that required revision. And then there was also obviously this significant dispute about, the role that, bijural legal analysis plays in common law Canada. How far can you rely on Quebec civil law? And so that was something that I had to, revise the manuscript to address quite a bit as well. And then as far as waste tech, I don't know what your reaction was to it. I'd actually be interested to know, but I was actually surprised to some extent at the framework the court adopted for the duty to exercise contractual discretion in good faith. I certainly agree with how the court defined reasonableness based on the idea of contractual purposes. And, you'll see in the book, I actually rely on this concept from Waste Tech to argue, for like a more general idea of how reasonableness works in contract law, different than administrative law. It's not based on an external standard of objectivity. It's really based on the agreement, is kind of the benchmark for assessing it in a whole bunch of doctrines, not just this one. But I wasn't expecting them to hold that the duty is mandatory. It's something the parties cannot contract out of.
Right.
That I thought was a very important but unforeseen development for me anyway. So because prior to Waste Tech, courts had always treated it as an implied term, and so I had originally had my book set up in a way where I had a separate chapter for the duty of honest performance because it was mandatory, and then I had 3 other duties from Basine that were all implied terms. And I ended up, putting them all into one chapter because, now 2 of them are mandatory and 2 of them, there's a question mark about whether they are or not. And so I think in that regard, Waste Tech was quite important in terms of elevating, that duty to the status of a mandatory one. It suggests,
Sure.
that may be an ongoing project. So,
Yeah, it is perplexing in that you mentioned the organizing principle of freedom of contract, which runs through the various doctrines of contract law. That is reflected in how the court says you do the reasonableness analysis under Waste Tech. You look at what the parties have agreed to, the purposes of the contract, and the assumption is that the parties themselves subjectively intended that the discretion that they were conferring on one of them would be exercised in accordance with those purposes. And that is concordant with the idea that the parties get to agree to whatever it is they've agreed to. And it's not for the courts to rewrite their bargain after the fact. So then to say that this is not something that the parties can release, they can't agree that a party has sole, unfettered, unqualified discretion in a certain respect, that in a certain sense there is always a qualification on discretion exercised under a contract, strikes me, and struck me at the time, as counterintuitive, and also creates difficulties for our clients and others who are drafting contracts, where sometimes the parties agree that one of the parties is going to have broad, unfettered discretion, and that's one of the things that's been paid for. It's part of the bargain. But evidently, that's not something the Supreme Court of Canada is on board with, which is interesting and not consistent with that overarching principle of contractual freedom. At least that's my view.
I think that is a very, very good way to look at it. It is certainly controversial in the law, not just in Canada, but in other jurisdictions, as to how far good faith should prescribe behavior that is not dishonest, but I hesitate to say merely unreasonable, because you can have behavior that is beyond the pale. But unreasonableness historically has been distinguished from dishonesty, and lots of cases have said there's a prohibition on dishonesty, but not necessarily unreasonableness. Like if you look, in the United States, for example, the Uniform Commercial Code originally defined good faith as being honesty in fact, and then it later added a concept of unreasonableness. But even there, a number of states have actually not adopted that expansion of the definition in some cases. And so and in other jurisdictions, like in England, I think are much more reticent perhaps to assert that there are mandatory obligations of reasonableness in a contract. There's a famous case called White and Carter, where the House of Lords held that there's no requirement to exercise contractual rights reasonably. So that that aspect of Waste Tech, I think, is important, and and I talk about it in my book. I think it really links into a broader concern, which Justice Kazir noted in his reasons about, the idea of abuse of rights being a doctrine that is part of the common law. Is it part of the common law? Not really. Going back to Allen and Flood, it's part of the civil law, not really the common law. But, gradually there are aspects of the common law that could be seen to reflect it. And so waste tech, I think, is very much at the forefront of that.
Right. Now, we will undoubtedly watch how that concept, that doctrine gets developed by the lower courts, and the Supreme Court may in another 5 or 10 years have something to say about it again. And I am going to take a big leap here and assume, Brandon, that now that you've put the finishing touches on the first edition of this book, that you are not done with the organizing principle of good faith, nor it with you, and that you will continue to be an astute and attentive watcher of this area of the law. Maybe we will get a second edition of this book before too long. As you watch the development of the doctrine in this area, what are the unresolved and important issues, or the issues where you think there's going to be emerging new trends in the jurisprudence that we and others should watch out for?
Yeah, I mean, it's funny you asked that. I actually just wrote an article for Law 360 that I think came out today on what some of the primary issues are that are unresolved. And so, as I note in that article, I mean, I think, the biggest question, arguably, is whether there's a duty of good faith in contractual negotiations.
Right.
I think that's a huge issue that the Supreme Court left open over 20 years ago on Martel. It's not entirely accurate to say that it's undecided, because there is some law that says, when parties have a binding pre-existing or preliminary contract in place and they negotiate pursuant to it, because it requires negotiations on like a renewal or something like that, then duties to actually perform the contract in good faith can also regulate their behavior during the negotiations. But how that works and what the obligations are in that setting are very much still being worked out. So I think that's probably one of the biggest issues, and will likely go to the Supreme Court at some point. I think another issue is one that I alluded to a couple moments ago, which is whether these other two situational duties of good faith, like the duty to cooperate and the duty not to evade obligations contractually, are they mandatory doctrines? Or like waste tech and Basine, like the duty of honest performance and discretion, or are they only implied terms that you can agree to exclude? Those duties actually go back. At least my thesis in my book is they can be traced back to cases from like the 18th and 17th centuries. Like, they are very old requirements, and so I suspect at some point that the Supreme Court may elevate them to the status of mandatory duties as well, to create synchronicity really with the other two. But that I think would be part of making the law more coherent and less piecemeal, which I think was really what Basine was seeking to do. So, but that's an open question, and there's a whole bunch of other questions too. That, and again, these are all dealt with extensively in the book. If you're looking for discussion,
I should hope so.
But like one for example would be the duty to exercise discretion. Well, what is discretion? How do you go about defining what contractual discretion is? Like, you'll recall that in Callow, Adam, the Supreme Court, we argued that there was a without cause termination right, and it was a form of discretion, and therefore it was subject to the duty to exercise discretion in good faith. And they left that open and didn't deal with it, and just held that they could do it on the duty of honest performance. And there's a couple of paragraphs where they say, well, some have analogized that kind of a contractual provision to an absolute right, which shouldn't be viewed as a discretion. And what that really is an allusion to is there's a whole body of law in England that distinguishes between like a bilateral power to do something in an agreement, like terminate, not terminate, versus a power of choice that gives you the ability to select from a multi, like a menu of options. And it's really only in the latter scenario that the duty to exercise discretion reasonably would apply in the English jurisprudence, or at least some of the English jurisprudence. And so the degree to which that is going to be accepted in Canada, I think, is very much an open question. And then just as a last point, there's another case, Adam, that you and I did together. You may remember it's called Matthews and Ocean Nutrition. A case that we did in 2020 with an excellent employment lawyer from Tim Lawson, where we represented the Canadian Association of Counsel to Employers as intervener at the Supreme Court. And the court in that case left open whether employment contracts are subject to a reciprocal duty of loyalty that applies throughout the life of the employment relationship. As you know, currently the major duty of good faith that employers owe is a duty to, it's a duty to treat employees, in a good faith way in the manner of how they dismiss them. It's much more narrow than the one
Yes.
the court, mooted in Matthews. And so that's also something that's left open and I think is a big issue.
So let's address ourselves to those whom we hope will buy your book. And there are, of course, many of them. It's coming out just in time for people's Christmas shopping at the beginning of November. I'm certainly expecting a 2-volume gift under my tree on Christmas morning. But all of us who are practicing law and who are studying law have at least one other book on our shelves that deal with contract law. And our law partner, Jeff Hall, has an excellent one on contractual interpretation. There are texts that are familiar to university students, to academics, to law librarians. There's an awful lot in this market. And so why do you think there's a need for a standalone book on good faith? Why is this 2-volume tome that you've prepared a necessary addition to a complete library on contract law?
Yeah, I mean, I think that's an important question. And so I guess I would just start by saying, we are very fortunate in Canada to have several excellent books on contract law. And certainly over the course of my career, we have seen new books, be published that, weren't there when I started, that have very much contributed to our understanding of the law of contracts. And each of them contributes particularly to our understanding of good faith in contracts. And I've tried to cite them extensively throughout my own book. And so I in no way would suggest that you shouldn't read those books to see what they say about good faith. I think they have a lot of very important points. But the reason why I believe that a standalone book on good faith can play a role is that the vision of contract law that emerges from Basine is very much a revolutionary one, in my view, because it really encourages us to re-examine the law of contracts in general. And consider how numerous doctrines within it are influenced by good faith, are influenced by other organizing principles like freedom of contract and commercial certainty. And it is very difficult to provide a complete account of this without really writing a book that starts from that perspective. And so that's what I've attempted to do in my text. Other books on contract law, are excellent in their own ways. They're not really written from that perspective. They may predate Basine, so they weren't really taken from the ground up to consider how Basine frames contract law, and they couldn't obviously be expected to be. So my book is trying to offer a bit of a different perspective on contract law, which takes the Basine decision as its starting point. And I hope that may be helpful to some parties. And I guess I would just say a related point is that good faith in contracts is an incredibly rich and expansive concept. I mean, it really infuses the law at every stage and has been present within it for thousands of years. And I don't think I'm exaggerating when I say there's a lot of cases in this area and there's a lot of academic literature in this area, and it's not limited to Canada. There's stuff around the world. And so to provide to try to provide a comprehensive account of that in a general contracts text is very difficult. I think you really need a book that's devoted to it. And certainly, as you said, my own book is 3,000 pages. So obviously there's a lot to talk about there.
Absolutely. So who do you hope will read this book? I mean, are you writing for the judiciary? Are you writing for the academy? Are you writing for people like you and me who are out here in practice, just trying to get through the day and give the best advice we can to our clients, or is it all of the above?
I mean, it's probably all of the above. I mean, I do think it will be useful in a number of settings. And I think that because I think that the law of contracts itself is one of those unique areas that is very much a matter of general interest within the legal system. So contract law provides the foundation for a whole number of substantive areas like employment law or insurance law or the law of guarantees or whatnot.
Sure.
And it's important whether you're a solicitor, you're a litigator, you're a judge, you're an academic, it's important to all of them. And so, there's a number of different audience groups, I think, who would be interested. So, solicitors and in-house counsel who are involved in drafting contracts, I think the book would help provide them with a window into how their agreements may be treated by the courts. It's, good faith is hard to prepare for from a drafting perspective, because it can really operate irrespective of the contractual terms in some cases. So you need to kind of know what the law is beyond, what the terms in the contract are. And that's a difficult thing to do, I think, in some cases. I mean, it's hard to keep track of all of, the cases that are constantly coming out on this. And so
Yeah.
having I think a summary of that would be useful. As you know, Adam, as a litigator, and I'd love to get your perspective on this. I mean, I think the book would be helpful as well, for them. I mean, I think, the fact that there is such a large and growing body of law in Canada on good faith means, from a litigator's perspective, that there's a lot of litigation on good faith.
Yeah.
And so, and there's lots of nuances in how the law has evolved, and it's hard to kind of piece that together without a guide. And so, I think the book will provide that guide, whether you're looking for a 50,000-foot overview or you just want to look, for a discussion of a highly specific matter, like how do you assess expectation damages for breach of the duty to cooperate, for example. I think litigators will find that useful. I think legal academics and students will be interested in it. As I said earlier, there's fairly detailed discussions of the historical and comparative aspects of good faith in different legal systems. And there's interesting questions of sort of like, law theory, how organizing principles operate within the law of contracts generally. Whether good faith imposes limits on the exercise of common law rights, like the right to terminate a contract on a repudiation, for example. There's not a lot of resources in Canada that really, look at those issues in a comprehensive way. And then I guess lastly, my hope, and, hopefully it shakes out this way, is that courts will find it helpful in developing the law. And here I would just emphasize that, the book is written as a treatise. So I've attempted to draft it as really a systematic exposition of the law that's written from the perspective of a single voice, in which, you have different parts of the law that are compared to one another and their rationales are explored, and, how they fit together is considered. And so it's not like it's a series of isolated chapters that have been combined together into a book. It's actually, systematic. And one of the most difficult things I think for courts to achieve in the law of contracts is coherence. So developments in one area, they conflict with another, they ignore another. You can have piecemeal doctrines, and that's exactly, what had happened prior to Basine. And so my book endeavors to explain contract law in a way that will contribute to coherence among the different aspects of it involving good faith. And so I hope that, that may prove useful to judges.
I have no doubt that it will. And I know that from the perspective of a practitioner, there's sufficient awareness now, particularly among sophisticated clients and law departments at some of the large institutions that we and other lawyers represent, that good faith is a thing, and that there are claims that can be asserted for breach of duties that arise under the organizing principle of good faith, and that there's the prospect of new duties that fall under that organizing principle being recognized and enforced by the courts. And so clients are often asking, is there a good faith claim here? Can we plead good faith? And I think if you talk to practitioners out and about, there is hardly a breach of contract claim that is issued now in the courts of common law Canada jurisdictions that doesn't plead some kind of a breach of a duty of good faith, because lawyers think, well, we don't really know where the courts are going to take this, and we know that there have been novel, well, maybe not so novel, but claims that have heretofore not been expressly recognized in our law that have been given effect by the appellate court. So we better plead this just to be sure. And it would be incredibly useful to me, speaking only for myself, to have on my bookshelf a resource that I could look to see, all right, am I completely freelancing here, or am I grounding what I'm pleading here, which is something I have an obligation to do, in the established jurisprudence, in the doctrinal basis for the duties that have been recognized to date in the court? And what are those duties, and how can I fit my client's case within them? Or conversely, if I'm receiving a claim on behalf of a defendant and figuring out how to defend it, it's going to be incredibly useful to see how the claim that's been asserted does or does not fit within the recognized areas of the doctrine, the recognized claims that have arisen under this expansive organizing principle. So I think I know the answer to this question, Brandon, but please confirm for me that your book is finally going to give me the confidence I need to confidently explain to clients that yes, you have a claim for good faith, at least as well as we can possibly discern, or yes, the other side is completely making this up and you've got nothing to worry about. Will Brandon Kain ride to my rescue in those moments?
Well, I certainly hope that I will, Adam. I mean, I can't guarantee anything, but
well, I can just call you, which most people can't. So they'll have to content themselves with your book.
Of course. No, I mean, yeah, I have very much tried to do that. And I think, one of the things in this book, I think, and it flows from, having done a lot of appellate litigation, is I tried to very much write this book from the perspective of the appellate jurisprudence. Like, a lot of it's very much a book about contract law in the Supreme Court of Canada and in the intermediate courts of appeal in Canada. I mean, it is easy to go on CanLII or any sort of legal database and find lower court decisions that will say virtually anything you want about good faith. But as to like how grounded they are in the ultimate legal theory and principles, that's more difficult to really understand. And so what I've tried to do is provide, very much drawing from, these appellate decisions, like what are the first principles for how these different areas of the law work, and then supplement them with, illustrations of factual patterns within lower court decisions that, sort of, provide nuance to how those appellate, principles may operate. And so that's kind of, very much part of how it's written. And I think it will provide people with guidance about, the most difficult part of it, really, which is how ultimately these larger principles work.
Well, Brandon, I have a funny feeling that as time goes on, we will see this book cited by lower court decisions, which will decreasingly be unmoored from the doctrinal underpinnings of the doctrines of good faith. And that will be an enormous contribution of which I know we will all be very proud as your colleagues, and I hope you'll be proud as well. Before we leave it off for this conversation, any last words for our audience, encouragement to buy the book, concluding thoughts on good faith and its discontents?
I mean, I actually, if I may, would just like to very quickly thank some of the people who, have been instrumental in developing the book, and there's been a number of them. And so obviously, like, first and foremost, I want to thank my wife and family who've really put up with a tremendous amount of stress and effort on my part in drafting this. I obviously just could not have done this without them, and the book is dedicated to them. I would also like to thank the Honorable Tom Cromwell, who very graciously agreed to write the foreword for the book. Justice Cromwell is really one of my legal heroes, and he's the author of the Basine decision. And so, his participation in this project really sort of meant the world to me. I'd like to thank our late friend and partner, Neil Finkelstein, who led the charge on the Basine appeal and encouraged me to write the book. I don't think that Basine or the book would have happened without his amazing energy and his intellect. And lastly, I'd just like to thank my colleagues at McCarthy Tétrault and my clients who supported me in this endeavor over many years. The ideas in this book are very much a product of a decades-long collaboration with them, and I hope they find them interesting. So,
well, as one of those colleagues, Brandon, your thanks are not necessary. We are enormously proud of you and of this great contribution that you've made to the legal literature and to the practice of law. So thank you for devoting the time that was necessary to get it done. We know it was a huge lift on your part. And thank you for taking the time to talk to me for this hard-hitting interview from a critical interviewer who's not at all enamored of your contributions to the law and hugely proud to be your friend and colleague. For everyone who's listening, the book is Good Faith in Canadian Contract Law by our own Brandon Kain. Find it at all fine bookstores or wherever LexisNexis sells its wares in early November 2024, just in time for Christmas. Thank you, Brandon, and thanks everybody for listening.
Thank you, Ed.